Let's be honest about something most people don't want to think about. Your entire life is inside your phone, your messages, your photos, your banking apps, your travel confirmations, your location history, your private conversations at 2 a.m. that you would never say out loud in public. And yet most people hand that device over during police encounters with less hesitation than they would hand over their wallet. Now here's the question I want you to answer honestly in the comments. If a police officer asked to look at your phone right now, would you know exactly what your rights are, or would you feel pressured to comply? Drop your answer below. I'm serious, because once you understand what's actually happening out there, you may realize you've been assuming you're protected when you're not nearly as insulated as you think. And as we move through this, I'm going to show you where the real risks are, especially for travelers moving through airports, highways, and border checkpoints. Let's start with the basic rule most people have heard. Police generally need a warrant to search the digital contents of your phone. That principle was reinforced by the Supreme Court in 2014 in a case that changed the landscape of digital privacy. The court recognized something obvious but powerful. A modern smartphone is not just another physical object. It is a portal into your entire private world. That decision made it clear that, after an arrest, officers cannot simply search your phone incident to arrest without a warrant. That sounds reassuring. But here's where people get comfortable too quickly. Because while the rule exists, the reality of how searches happen is far more complicated. And the tactic I'm talking about isn't loud, it's not dramatic. It doesn't involve smashing passcodes or high-tech hacking scenes. It's subtle, it's psychological, and most people walk right into it. The silent tactic is consent, not forced consent, not shouted orders, not threats, just quiet conversational consent. An officer says something like, "Mind if I take a quick look at your phone to clear this up?" Or, "If you don't have anything to hide, it'll only take a second." Or even, "Can you unlock it so I can confirm that message?" And in that moment, without realizing it, you've just waived the strongest privacy protection you had. Let's unpack how this actually works. Under the Fourth Amendment, warrantless searches are generally unreasonable unless an exception applies. One of the biggest exceptions is voluntary consent. If you give permission, officers don't need a warrant. They don't need probable cause. They don't need to justify it the same way. And here's the part that makes this silent. Consent doesn't have to be in writing. It doesn't have to be dramatic. It doesn't even have to be enthusiastic. It just has to appear voluntary under the totality of the circumstances. That means you're calm. Yeah, sure. On a body camera can become the legal foundation for a full digital search. Now think about how often that scenario plays out. You're pulled over on a highway late at night. Maybe you are speeding. Maybe your brake light is out. The stop-start's routine. License, registration, insurance. Then casual questions. Where are you headed? Who are you meeting? Is that your phone on the seat? If the officer notices a text notification pop up with something that catches their eye, even something harmless but ambiguous, curiosity turns into inquiry. Can you unlock that for me? It feels minor. You think you're clarifying something. You want to look cooperative. You don't want to escalate. But what you may not understand is that unlocking the phone can expand the scope far beyond what you expect. Once inside, officers can scroll. They can search. They can look at photos, call logs, app activity. The extent depends on how broad the consent is interpreted, and courts often interpret consent broadly. Now let's bring this into the travel context, because that's where many people get blindsided. Airports operate under a different security framework. When you pass through TSA screening, you're already in an administrative search environment designed for transportation security. That doesn't automatically mean law enforcement can dig through your phone without a warrant, but the lines blur when security concerns are raised. If airport police approach you based on suspicious behaviour, an unattended bag, or a misunderstanding about a travel document, they may ask to see something on your phone: a boarding pass, a confirmation email, a text from a friend you claim you're meeting. You show them one thing, they see something else. And again, consent opens the door. It's even more complicated at international borders. At ports of entry, Customs and Border Protection officers operate under what's known as the border search exception. Courts have historically allowed broader search authority at the border, including searches of electronic devices without a traditional warrant requirement. although the standards are evolving and vary by jurisdiction. If you are re-entering the country and an officer says, "Please unlock your device," the legal terrain shifts dramatically compared to a roadside stop in the middle of Nebraska. Many travelers don't know this. They assume that because they're American citizens, their phone is untouchable. That assumption can be dangerously naive. Now let's talk about how officers think during these encounters. Their job is to gather information efficiently. If there's ambiguity, they probe. If there's resistance, they assess whether that resistance is meaningful or just emotional. If there's compliance, they follow the opportunity. When you consent to a phone search, from their perspective, they've just saved hours of paperwork and judicial process. No warrant application, no waiting for a judge, no drafting affidavits establishing probable cause. It's fast, clean, legally safer for them if documented properly. So how do you protect yourself without escalating the situation? First, understand that you have the right to refuse consent in most domestic law enforcement encounters. Refusing consent is not a crime. It is not obstruction by itself. It is not an admission of guilt. But here's the nuance. How you refuse matters. If you say, "You're not touching my phone, that's illegal," in an aggressive tone, you shift the emotional temperature of the encounter. That doesn't help you. If instead you say calmly, "Officer, I do not consent to a search of my phone," you have drawn a clear legal boundary without confrontation. That sentence is powerful. It preserves your rights. It forces the officer to either develop probable cause for a warrant or move on. But there's another layer that people rarely think about: biometrics. Many modern phones unlock with fingerprints or facial recognition. In some jurisdictions, courts have drawn distinctions between compelling you to provide a passcode, which is testimonial, and compelling biometric unlocking, which may be treated more like providing a physical characteristic. The law is still developing in this area, and it varies across circuits. But from a practical standpoint, disabling biometric unlocking before entering high-risk environments like protests, sensitive travel situations, or border crossings can add an additional layer of protection. Because compelling a memorized passcode raises stronger constitutional arguments than pressing your thumb to a screen. That doesn't mean you should live in paranoia. It means you should understand the mechanics. Now let's consider a realistic scenario. You're driving back from a music festival, late night, out-of-state plates. You get pulled over for a minor traffic violation. The officer smells alcohol, but you insist you haven't been drinking. You hand over your phone to show a rideshare receipt from earlier in the evening. In the process, they see a group chat discussing something unrelated but suspicious sounding out of context. What started as a traffic stop just expanded, not because they hacked your phone, not because they violated a warrant requirement, but because you voluntarily exposed digital information beyond the original purpose of the stop. Another scenario, you're at the airport, you're running late, security flags your bag for additional screening. A law enforcement officer approaches because of an item that looks questionable on the X-ray, but turns out to be harmless. They ask to confirm a detail about your travel itinerary and request to see your email confirmation. You unlock your phone and hand it over. While scrolling, they notice something unrelated that triggers additional questioning. Now you're in a secondary screening room, missing your flight, answering questions you never expected. Was that unconstitutional? Not necessarily. Was it avoidable? Possibly. This is why awareness matters more than outrage. There's also the issue of data extraction tools. In some cases, when officers do obtain lawful authority, they use forensic software to copy large amounts of data from a device quickly. That's a separate discussion involving warrants, scope limitations, and suppression issues in court. But again, many of those situations begin with something small, a consensual look, a casual unlock. And here's something that might surprise you. Sometimes officers don't even need your phone physically to gather digital information. Location data can be obtained from third-party providers through legal process. Social media content can be accessed if public. Cloud backups may be subject to separate warrants directed at service providers. Your phone feels like the vault, but in reality it's often just the key. So what's the real takeaway here? It's not that police are secretly hacking phones at every traffic stop. That kind of fear-based narrative gets clicks but distorts reality. The more common risk is far less dramatic and far more common. You agree to something without understanding the consequences. And that's why I always say, The most dangerous phrase in a police encounter is not something shouted in anger. It's something said casually. Sure, go ahead. Because once you say that, you can't unsay it. Now let me address something practical. If you are arrested, officers may seize your phone as evidence. They may hold it while seeking a warrant. That's different from searching it immediately. Seizure and search are not identical under the law. The timeline matters. The justification matters. If you're ever in that situation, your roadside debate will not determine the outcome. A courtroom will. Your goal in the moment is to avoid making the situation worse through unnecessary consent or incriminating statements. And let's be clear, none of this is about hiding criminal activity. It's about understanding that privacy protections only function when you assert them intelligently. Most people think rights are automatic shields. They're not. They are tools, and tools only work when used correctly. Before we close, I want you to think about your own habits. When you're nervous, do you over-explain? Do you try to appear extra cooperative? Do you unlock your phone reflexively to prove something? That instinct to prove innocence often creates exposure. Calm refusal is not hostility. Silence is not guilt. Asking, "Am I required to provide that?" is not defiance. It's clarification. And if you ever find yourself replaying an interaction later thinking, "I shouldn't have handed that over," then you already understand the core lesson here. Protection doesn't come from viral slogans or dramatic standoffs. It comes from knowing when to speak, when to stay silent, and when to simply say, "I do not consent." Because in a world where your entire life fits in your pocket, the quietest decisions often carry the loudest consequences.